My name is Siavash. I'm from CIFILE, and it's a pleasure to be here with you and all the participants. I'd like to welcome everyone to another webinar by CIFILE. Today, the topic is about the future of international law, and we have two great speakers, Dr. Poorhashemi and Dr. Sreenivasulu. I'd like to talk about CIFILE first and introduce that one and go to the speakers. So CIFILE is an independent, non-political and private institute working with groups of international lawyers and scientific experts across the globe to promote the implementation of national and international law. CIFILE facilitates access to justice and legal professionals around the world and provides legal services, including but not limited to international law expertise, contract law, immigration, finding a lawyer in a different country, online courses, publications, and Journal of International Law. CIFILE is headquartered in Toronto, Canada. Right now it's about 10:01 a.m. and it works closely with many national and international lawyers around the world. So today we are going to start the webinar with Dr. Poorhashemi. I'd like to introduce him to you too, and then we will listen to him. Dr. Poorhashemi is the president of the Canadian Institute for International Law Expertise, in brief CIFILE, and an expert in international law. He has received his postdoc in international law from Canada, and he is providing legal opinions on international law as an expert before the foreign and Canadian courts. So, his teaching and research interests are in the areas of public international law, international criminal law, and international environmental law. He has published many books and articles in each of these areas. He is also the editor-in-chief of the CIFILE Journal of International Law, or in brief, CJIL. So, thank you again for joining us in this webinar. I will ask Dr. Poorhashemi to start, and we're going to enjoy his speech in public international law challenges and opportunities. Dr. Poorhashemi, please.
Okay. Hello everyone. I don't know. It's
Yeah, we can hear you, Doctor.
Okay.
Yeah.
Hello.
We can hear you, President.
This is a great pleasure to see you all in this webinar on the future of international law. I would like to thank our scientific members, specifically Professor Sreenivasulu, Professor of Law at National University of India, for accepting to be part of this webinar as a speaker. On behalf of the Canadian Institute for International Law Expertise, I would like to welcome you all today, as well as CIFILE's members, lawyers around the world, and other distinguished participants in this webinar. At this historical moment of COVID, I would share with you a challenge and opportunity of international law to show you a different picture of view of international law. In fact, thinking and rethinking about the past, future, international law will help us to define our place in international law practice, because both national and international law cannot be so easily separated each other. We are witnessing an extremely serious situation which is changing everything in our personal and professional life. In fact, the emergence and spread of COVID-19 has created and still creating health issues, economic challenges, political crisis, and social conflict around the world. These challenges and conflicts leads international community to re-evaluate global governance and international structures, which is based on the Second World War and post-Cold War. The pandemic emerged new era of international law and society. It would not be similar to the pre-coronavirus. In the same way, we are observing in many countries the rise of nationalism, populism, extremist ideologies, human rights violations, and kind of anarchy in the international society. The United Nations in 1945 has established a current international law based on some principles such as equality between states, self-determinations, international cooperation, respect of human rights, and peaceful conflicts resolution in international law. We can see today these principles are transforming to unilateral approaches in practices which lead to the geopolitical tensions and threat international peace and security. The United Nations cannot keep its promise to establish international peace and security, territorial sovereignty, balance of powers, common interest of humanities. The COVID-19 is changing and even damaging the global values, international principle and system that have been fundamental in international governance for more than 7 decades. The Charter of the Charter of UN and the Statute of ICC have defined the current international system. Based off my presentation, I would like to talk about some potential challenges for the future of international law arising from COVID-19. One of the challenges is the threat to global peace and international security. Here, the question is whether COVID-19 could be a threat to international peace and security. Surely the pandemic could affect global peace and security. The pandemic is causing political conflicts in national levels in many countries. Furthermore, coronavirus have a risk of conflict between some states, such as United States and China, India, Pakistan, North Korea and South Korea, and etc. In this situation, the United Nations has a limited authority to manage the global situation. Meanwhile, the multilateralism and international cooperation are essential to maintain peace and security, sustainable development, and human rights in this ongoing situation. The commitment to the peaceful settlement of international disputes is fundamental principle of the Charter of the United Nations. However, the existing world order is changing. Based on this projection, can we predict the pandemic will transfer world into a new order, new global order? The second challenge is economic confrontation. The pandemic could affect the global economic system, both at the level of production, distribution, and in the daily economic life of humans. It reveals certain deficiencies and weaknesses in the global economic financial system. The current world, based on the free market, is changing, and in uncertain situation can increase competition between the states. Confrontation is playing increasing role in international relation between countries. The multiplication of unilateral actions and the extension to the field of high and new technologies, economic sanctions, disagreement in international organizations could only some of the example of confrontation between a state in the future of international law. Another challenge is regarding the augmentation of international pressure for judicial action under the vast human economic loss caused by pandemic. Some individuals and countries are willing to file lawsuit or complain against China or another countries. In the current state of international law, the claimant state or individual is required to prove the negligence or breach of international obligation to this or to receive any compensation regarding defendant state. According to the fundamental of international law, violation of a state international commission of any international wrongful act engaged international responsibility. Thus, the claimant state or individual should prove that China or other country had violated international obligations. In this case, the potential legal action against each other could be additional competition between states. The Charter of the United Nations and invites some states to settle their international dispute by using peaceful means, including arbitration or judicial settlement. However, the international justice system seems confronted to several limitations and deficiencies. Another challenge, international institution, the global challenges and require global participation and cooperation. The world after pandemic will raise the interest issue of reforming functioning of international institutions such as the United Nations, and more specifically the Security Council. The current composition of Security Council is no longer reflect contemporary international society. The right to veto or reform of permanent members require providing a solution for the functioning of the council and the maintaining the peace and security in the world. The issue is whether we can imagine or dissolve this actual United Nations and establish another United Nations in the post-coronavirus. Besides, the General Assembly of the UN as a most representative and democratic forum has a crucial role to play for the normative and institutional development of international law. The next issue is global issue. The pandemic proves that health issue has no border. In international law, become global health problem. And this fact, national state and international institution can no longer view health as a border issue, as they often did in the past pandemic. The rapid development of communication across the nations through travel and trade has facilitated transmission of the disease to country and to another country. In this context, can we expect the emergence, the development and international health law as a new branch of international law? Also, the widespread and disease in developed and developing countries have shown that the World Organization leadership has failed to manage the growing trade in the world. In some states, they declare that the effectiveness of the WHO, explicitly at the time of the global crisis. The next challenge is global governance in the context of COVID-19. In fact, the global crisis management regarding the pandemic led to the emergence of new actors in international law, which now plays more preeminent globally and in the multi-actor and multi-level governance in the world. In such a situation, some developing countries are willing to have more authority and position in global governance. In this context, COVID-19 is changing the global distribution of power among the states, which could have a fundamentally impact in the international legal and international institutional system. In this perspective, all states should continue to foster multilateralism, collaboration, and cooperation to reduce health issues and to peace, security, and other challenges caused by COVID-19. Then we are also facing environmental issue and concern. The coronavirus and biodiversity are linked together. According to some reliable scientists, the COVID-19 disease started from Wuhan, China seafood market, where wild animals, including remote birds, rabbits, bats, and snakes, are traded illegally. Some of the scientists believe that the new coronavirus genetics is almost identical to the one found in bat. So environmental protection, especially biodiversity protection, is related directly to the pandemic. In this context, international society should continue to contribute the effort to address ongoing challenges, to protect biodiversity, illegal wide trade, waste management, and climate change, of course. Finally, social distancing and work remotely are supporting to determine how social media and virtual communication are crucial for the humanity. Existing international law will transfer into new form of law based on new technology and virtual life. International organizations are working to develop a new model to create a new workplace for their employees and clients. So new technologies change not only international legal institutions, but also international actors' behavior and communication in the world. In conclusion, the pandemic has caused an unimaginable devastation and hardship to the international community. It's changing the substantive and institutional aspect of international law. The outbreak will have lasting economic and political and social consequences in every corner of the globe. International law as a body of law that governs relationship between a state, international organizations, and private persons in a global framework, exposing its vulnerability no one ever existence, which means international law would not be same as before. Besides, the conflict between national sovereignty and global values of the international community, such as environmental protection, sustainable development, and human rights, remain unresolvable. International law for sure must show its effectiveness, its capability of adapting new reform based on the democratization of the international institutions. Such democratizations will help to empower the decision-making process and improve transparency in the world. There are other challenges and opportunities in the future of international law which are remaining for future research and discussion. Thank you for listening to this presentation. And Mr. Siavash Hidayati, if you want.
Yes, thank you so much, Dr. Poorhashemi. It was just interesting, short, but completely you covered the topic. Thank you so much. So if the participants have any questions, hopefully we will have a chance at the end of this webinar, after we hear Dr. Sreenivasulu's talk on just future of international law. And the professor will talk about international intellectual property law, but I'd like to introduce him a little bit, definitely most of you know him already. And the fact is, when I was looking at his resume and academic profile, I noticed that it's too long, and he has been really, really active in this field. I thought that I need hours and hours to go one by one into his activities, those articles, and those conferences that he has attended internationally. So it was difficult to summarize, but because of short of time, I'll just very briefly introduce him and then we will go on. It was a pleasure to meet Dr. Sreenivasulu here. He is the professor of law at School of Technology Law, National University of Juridical Sciences in India. He also specializes in intellectual property laws, biotechnology laws, and informational technology law, multidisciplinary interfaces of law and policy, civil liberties, and jurisprudence. As I mentioned, Professor Sreenivasulu has different books in the field of intellectual property, human rights, and biotechnology and patent law, law of copyright, and I told you the list is endless, and it's a pleasure to have you in here. So, Professor, it's a pleasure to have you in this webinar, and we are ready to hear your talks. Thank you.
Thank you, my dear colleague. Good morning, Canada. Good evening, India. I welcome all the people who are participating in this webinar, and a special welcome to my dear friend, the President, Abbas Poorhashemi. International intellectual property law is the topic that I'll be speaking in this webinar, taking a clue from where President Poorhashemi left while giving his introductory speech regarding the future of international law in the context of COVID-19 and the situation that we are having and the future of international law. Taking clue from there, let me see through how intellectual property law at international level is going to have its future in the post COVID-19 scenario, or rather preparing ourselves in terms of international law to see through post-COVID scenario. the future of international intellectual property law, aftermath of COVID-19, while looking through the text and context of international intellectual property law as such. Generally, we believe that international law gets formulated through certain principles which are agreed upon by the international society, or for that matter, it gets evolved through the general consciousness of people across the world. The so-called civilized nations contribute immensely towards the formulation and establishment of international law in general. But that is not the only way by which international law gets formulated. You have got treaty making mechanism through which also the international law gets formulated. And also we have private pacts or private agreements, conventions between a few international societies or nations for that matter, where we get to see the operational purview of private international law. And perhaps it is the treaty making mechanism or law of treaties, which is part of the general international law, which is quite relevant not only in the context of future of international law, but as well in the available or existing legal framework of international property. Perhaps I reckon that
Professor, we cannot hear you properly. I think there's interruption in the line.
No. Yeah?
Yeah,
Am I
now I
audible?
think it's better.
Yeah.
Yeah, please go ahead.
Yeah. So this treaty making mechanism, whatever is recognized as one among the different sources of international law, is very much responsible for the growth of international law. In the similar way, when we would like to foresee the future of international law, aftermath of COVID-19, in fact, again, it is this treaty making way of formulating international law, which shall be taken resort to in foreseeing the future of international law, not only in the context of COVID scenario, but as well in the context of international intellectual property law. And we have read, experienced, and seen in the news that number of laboratories, number of universities in different nations, they are trying to come out with different vaccines for the purpose of controlling this COVID virus in whatever possible way. And in that context, we need to talk in terms of reformulating, adjusting, amending the international health law or international medical law in whatever nomenclature that you would like to call it as. In similar way, since it is about new and innovative vaccine or a new drug, pharma, whatever is getting developed for the purpose of curing, controlling, or treating COVID, it also comes within the purview of international intellectual property law as well. I see this kind of very viable and valid connection between the present COVID scenario, which is quite relevant for the purpose of discussion on international intellectual property law, which is also aiding, assisting, and helping in the formulation and reformulation of international law, both in the general context and as well in the special context of COVID-19. So as I was mentioning, it is the law treaty making mechanism which is the most viable most relevant method of formulating not only the general international law, but as well the international intellectual property law. If you look at the crux of international intellectual property law, which is basically structured, formulated on the basis of treaties, agreements, compacts, or conventions. I can say that the entire gamut of international intellectual property law is basically resulted out of a number of treaties, number of conventions, a number of agreements that have been rolled down at the international level. The entire gamut of law, whatever we have got at international level on this point of intellectual property law is basically resulted out of treaties that have been made by the international society. I can say that there are about 25 treaties that have been formulated at international level, which have actually structured the basic frontiers, the basic fabric of intellectual property law at the international level. So going beyond the general principles, general consciousness through which general or public international law gets formulated, through the general consciousness of civilized nations, or certain conventions, practices which have attained the letter of the law in the so-called civilized nations, which gets spread across the other nations. That is how, in general, most informally, the general or public international law gets formulated. That doesn't apply in the context of international intellectual property law. When I say this, it also includes the process of encouraging new and innovative innovations, including that of the innovations pertinent to finding vaccines for treating COVID as well, COVID-19 as well, or for the purpose of preparing ourselves in the post-COVID scenario, the ways and means by which you are going to reformulate, restructure the governance mechanism that you have got at international level through the lens of international intellectual property law, because whatever vaccine that you get to see getting released into the market, it gets through the lens of intellectual property law, because those scientists, those universities, those laboratories, or those nations would aim to obtain patent, would aim to obtain one or the other form of intellectual property on that so-called vaccine or vaccines, which are very much in demand, hugely in demand, right, aftermath of this COVID-19 scenario. So there is a need to revisit, have a look, and possibly overhaul the existing legal framework on intellectual property at the international level in this context of COVID-19. So as I mentioned, the entire gamut of intellectual property law at international level is formulated, is resulted out of a number of international treaties and conventions. Of different kind or different. These international treaties, which is the source of international property at varied levels, international, regional, national, and local levels, could be classified, categorized, or segregated into different classes, depending upon its own context or reasoning. Because these international treaties have not structured, but as well a holistic legal framework for the purpose of encouraging innovation and creativity at a domestic level, but the law is coming from the international level. It's not from blue, but it is coming from the international level. The intellectual property law is not made at a domestic level. The nations are not formulating intellectual property law. Nations have been asked to formulate intellectual property laws at a domestic level because of the mandate that law of treaties, international law, or the conventions, treaties that get formulated at international level on the subject of intellectual property law. Such being the case, when you look at the different types of treaties that are available, that are operational in the current scenario, you come across at least 4 different classes or categories these represent in their own context, wherein there are certain general treaties which have been formulated on the subject of intellectual property law. There are specific or individual treaties which are also formulated on the subject of international intellectual property law. When I say individual or specific intellectual property concerned treaties, it is with respect to any one area of intellectual property law, like a patent, copyright, trademark, so on and so forth. But when I say general intellectual property related international lawmaking or international treaties, I talk about the compound or generalized international treaties which discuss in general about not one or two segments of intellectual property, but more than 2, 3. For example, Paris Convention talks about at least 5 to 6 different segments of intellectual property. But at the same time, if you look at the TRIPS agreement, it talks about all the 7 or 8 different segments of intellectual property, right? So these types of general and as well as individualized or specific intellectual property lawmaking that you get to see through the law of treaties mechanism that is prevalent in the process of adding more value, adding more knowledge to the already available or existing cemented general international law. On the other hand, you have got another classification which can be discussed or debated, like substantive and procedural. When I say substantive international law or substantive international treaties on the subject of intellectual property, I'm mentioning about, or I'm actually referring about the subject, the actual subject that you get to protect under various segments of intellectual property law. For example, what is the subject that you protect under patent? How exactly the coronavirus treating vaccine can be protected as a subject matter of patent, or how exactly the literature pertaining to finding cure or vaccine to the coronavirus right treatment can be given protection under copyright. Like that, what actually you protect, the subject calls a shot here. So subject wise international lawmaking, which actually establishes, re-establishes, fine-tunes, overhauls or reforms, amends, reformulates the current subject, which actually the various segments of intellectual property law provide protection for. Of course, in the context of COVID-19, we need to revisit the actual established cemented subject that you have got under respective spheres of intellectual property, in particular patent and copyright. Because this pandemic has created such a situation where every nation, every government, every individual, every entity is actually looking for the vaccine, is actually trying to contribute in the possible level in the process of formulating a vaccine or making that vaccine once it comes out to be available at affordable prices for one and all, the general masses, right? So the subject, what actually you protect. On that basis, the substantive intellectual property law making has taken place through this treaty making mechanism under general international law. On the other hand, when you talk about how exactly this coronavirus vaccine, treating vaccine can be given protection, by what means, by what process, by what procedure, right? The procedural mechanism that is set forth respectively under different spheres of intellectual property law. On that matter also, you have got different types of international treaties which have been formulated and which have re-established the subject of general international law. So like this various segments, various sectoral basis classification that you get to see in the international lawmaking as far as intellectual property law is concerned: procedural, substantive, general, and individual. And likewise, the 20 to 25 agreements that, as I mentioned in the beginning, can be classified into these 4 broader categories. Certain international treaties are providing for the actual subject matter that you actually provide protection under intellectual property. There are certain international treaties which talk about the actual procedure and process through which you get through when you obtain intellectual property protection for your respective innovations, including vaccines, pharmaceuticals, medicines, whatsoever. There are certain international treaties which talk about, in general, various segments of from trademark that matter, plant treaties. And also there are sector-oriented international treaties, oriented, patent-oriented. So the entire gamut though got segregated into these four categories, it resulted in
Professor,
it is
again,
not
your
true
voice
in
is
the
interrupting.
consciousness.
I don't know, I think the connection is a little bit poor. Yeah, still it's breaking.
Okay.
Yeah,
Some connection issues.
yeah, I think it's getting back into normal.
Okay. Okay.
Yeah, go ahead, please. Now it's good. Thank you.
Yeah. What I'm trying to say is general consciousness, the contribution of general consciousness among us, the civilized nations, which is forming the basic crux of international law, general or public international law, is not going to be that effective in the context of international intellectual property, read with the current COVID scenario. It's not the consciousness, but it is the requirement now, right? You require vaccine, you require treatment for COVID. So you need to relook, overhaul your own general consciousness, right? In terms of formulating or contributing towards formulating international law in general. And for that, lawmaking, treaty law, process of lawmaking is the requirement that you need to have a relook at in the current context of COVID. So as I mentioned, in the later part of 19th century, when international society formulated this Paris Convention, the first international conventions on intellectual property, the Paris Convention, it actually spelled out the subject, it spelled out the letter of the law contributed by the so-called civilized nations in the codified form, which got rolled down from above, from international level to domestic levels. And it remains to be the first attempt by international society for the purpose of encouraging innovation and creativity at domestic levels by formulating intellectual property laws. So since the later parts of 19th century till 2020, in this time period of more than 100 years, international society happened to see at least 22 different international conventions, 22 international conventions or treaties that actually structured international intellectual property law. The latest contribution is the Marrakesh Treaty on Copyrights. Marrakesh Treaty on Copyrights 2014 happens to the latest entry in this segment of international intellectual property law, right? Which has got more than 22 entries. So this ranging from Paris Convention till the Marrakesh Treaty, there are a number of conventions, agreements, or for that matter, convention treaties and
yeah, Professor, again, the voice is interrupting and breaking.
Okay.
Yeah, I think it should be okay now. I think for a few seconds in the middle, it goes away and comes back. Should be
Right.
Yes, yeah, okay, go ahead.
Yeah, or maybe, yeah, there is quite a lot of distance, so it may be taking time.
Right, yeah,
right? That's also maybe there.
Yeah, thank you. Sorry for interruption.
Yeah, not a problem. So the nomenclature intellectual property rights law that itself is contextual, because under the garb of intellectual property rights law, you're actually talking about industrial property, because you are encouraging such type of innovation and creativity which can be industrially applied, which can be industrially or commercially exploited. That is the reason why when you begin the lawmaking process at international level through the Paris Convention, you happen to use the word industrial property, Paris Convention on Industrial Property. And now we have got this title intellectual property thanks to the TRIPS agreement, which uses this term intellectual property. So the point that I'm trying to put across is It is the industrially relevant intellectual property that you are actually trying to protect. For the purpose of protecting the innovations or creativity, which is commercially, industrially driven, international society happened to roll down the international intellectual property law through various conventions, treaties, and agreements. Right? This debate between industrial property and intellectual property has got a very, very silver lining thought involved in it, because in this debate, copyright law is not contributing. Initially, when we started lawmaking process at international level for this subject, intellectual property or industrial property, copyright law was not considered to be industrially, commercially relevant. That's the reason why Paris Convention does not talk about copyright at all. Copyright law was not covered as part of Paris Convention, though in the current scenario, copyright is very much covered within the broader intellectual property law framework. Because literature, creativity, knowledge that the copyright law generally deals with was considered not commercially relevant or commercially viable. It was considered to be divine. Knowledge was considered to be divine. Dissemination of knowledge was supposed to be meant for divine purpose, not for commercial purpose, not for industrial purpose. That's the reason why when you use the title industrial property under the Paris Convention, you thought that this property, copyright, though intellectually created, does not fit into the definition of industrial property. That's the reason why you kept it aside when you were formulating Paris Convention. But as the day progressed, slowly and gradually, when this media started booming large, print media, broadcasting media, television media, film media, digital media, right, where the copyright law subject matter gets used, reused, exploited and re-exploited in different ways through adaptations or translations in whatsoever way, then international society thought that there is much to talk about under copyright law. There is serious amount of commercialization that the entire subject matter of copyright law can be used for. So it is commercially driven. More than any other segment of intellectual property, copyright law is seriously commercially driven now because it is used in different contexts of media, in print media, radio, television, digital, and as well as film. Same subject matter, same work can be used in different ways by adaptations and translations. So now this media platform and its emergence and its looming large, and it's widely spread, when it is widely spread across the globe, it has created such a situation for the international society to reconsider its thoughts with respect to the status they accorded to this copyright law. That's the reason why now copyright law is part and parcel of your broader international intellectual property law framework. Therefore, what I'm trying to say is you are actually dealing with commercialized, commercially viable, industrially applicable, trade-related aspects of intellectual property, not only at international level, but at national level as well. That is, in fact, more clearly evidenced when you formulated this WTO TRIPS agreement, trade-related aspects of intellectual property. It is very wide, clear. It is only the trade-related aspects of intellectual property that you're actually dealing under the broader segment of intellectual property. This debate between industrial property and intellectual property has got another silver lining in it. That is, the third world is not very much keen to have international intellectual property law, rather intellectual property law at all. There is the north-south divide, which can be very clearly felt in the jurisprudence of international intellectual property law. Most of all, the entire contribution in the lawmaking process concerning intellectual property, it is the North which has contributed, going by the version of the South, right? Because South had hardly contributed in terms of lawmaking process or treaty making process concerning intellectual property. That's why South feels that intellectual property law, it is first of all coming from the international level, above, not from within, and that is also coming because of the major contribution by the so-called civilized societies or the so-called North. So the dialogue, the debate, the consensus between North and South is not having any connection. There is no fusion. That's a basic argument or basic criticism, allegation, or observation, whatever you call it as, that so South is having since day one as far as this international intellectual property law is concerned. The North-South divide is greatly felt. Even in the context of COVID scenario, if you take, if the vaccines have been produced, say in the so-called civilized nations, the South is feeling that it may not reach the South, the so-called developing world, because before it gets released into the market, right? In the north part of the world, the so-called civilized nations or developed nations, they may obtain patents on that, and by virtue of that, the prices of that particular vaccine may go up. It may not be affordable to general masses, and the so-called South or the developing nations may not be having that affordability to obtain license, to obtain assignment or authorization to use that vaccine or to purchase that vaccine for that matter, because of the huge cost involved in not only obtaining. So this north-south divide is seriously felt in the context of international lawmaking as well, as far as this particular lawmaking, treaty-making process is concerned, as far as international intellectual property law is concerned. And that's the reason why the South has always been having one or the other concern in this matters of lawmaking concerning intellectual property law at international level. If you look at the lawmaking that has taken place on the subject of intellectual property at international level, you get to see that the two regions in particular, USA and European Union, have seriously contributed in terms of formulating law at international level. And this is resulted out of serious types of agreements, compacts, or the contribution made by the civilized societies in both the segments of USA and Europe. And these two reasons have not only immensely contributed for this purpose of lawmaking at international level, and it has resulted in terms of their version or their vision to be incorporated in the lawmaking process of intellectual property, as a result of which the developing nations, the called South, could not get an opportunity to contribute their part or their version in this particular lawmaking process at international level. Most of these treaties or conventions which have formulated the international law on this point have resulted out of the bills or the versions or the policies enacted, formulated by these two regions. Even in terms of dispute settlement also, you get to see that mostly and often it is the USA and European Union which you get to see to be at the loggerhead heads or at different levels, contesting and contemplating their different versions. It may be at the WTO dispute settlement mechanism, or it could be at the International Court of Justice, or for that matter, European Court of Justice, or for that matter, World Intellectual Property Organizations dispute settlement mechanism or arbitration mechanism, whatever it is there in place for the purpose of settling international disputes. So what I'm trying to say is the contribution of USA and European Union can be seriously and vehemently felt in the process of lawmaking at international level. And that could be one among the different reasons why South always thinks that the region of European Union and the USA have got their say strongly, vividly, and widely, deeply felt in the process of lawmaking as far as intellectual property law is concerned. And South could not contribute much in terms of formulating law, but when it comes to implementation, it is the South which is implementing international intellectual property law to the core, because South is considered to be the wide market for whatever patents, copyrights, trademarks that entities obtain and market at the end of the day. So South's version is that though it is providing a wider market for various proceeds of intellectual property law, it is unable to get their due in this process of obtaining proceeds which could have resulted out of implementing intellectual property law at a domestic level. Not only that, in fact, in this global scenario where the entire intellectual property law at international level is formulated out of this law of treaties. As I mentioned, certain regions, certain jurisdictions are formulating certain policies, and when those policies get popularized, widely felt across the globe, and certain jurisdictions are rather forced to assent to it, give consent to it, and it is happening mostly in the cases of South. And the contribution, not only in terms of lawmaking, but the general consciousness, or for that matter, what you call it as the contribution in terms of capturing the minds of the people, the societies who live in the so-called South, right? Equal opportunity or equilibrium that one need to achieve in the process of lawmaking to balance different interests, different stakes, from north to south, from west to east, right? From US to Europe, from Canada to India. Probably that is not happening. And that could also be a point of consideration with regard to when we envisage future of international law in the context of COVID scenario, because huge market when you're having at South, when you release COVID vaccines or the medicine pertinent to COVID, it could be the South which could be having more demand, not just because of having huge market, but because of a huge consumer base where this vaccines or medicine pertinent to COVID not only get sold, but the vaccines are very much required here in the South part because of the market and consumer base. So the point that I'm trying to put across is, in the current global scenario, where the international intellectual property law, though made through international treaties and conventions, but this COVID has created such a situation wherein you had to revisit your local needs, look at your local aspirations, what is required at local level. When in the background of this pandemic, when the situation is very grim, right? People or societies or nations may not bother much about what is happening at international level and what is the mandate that the so-called international organization has leveled against me, against us, or what kind of obligation I will have to fulfill. But I have to look at my own people, my own society, which is having a great demand, where the society is living in sort of exigency or emergency. So the implementation of the current gamut of international law, not only in the context of intellectual property, but in the general scenario also, you need to have a localized view or localization of international law, or reformulating international law to suit the local needs, globalization and localization, right? You talk about globalization at international level when you get to see different 200 and odd countries to sign the dotted letter to get them involved, to get their assent. You talk about globalization, single market, right? By virtue of which you get the signature or assents, consent of different nations, bringing out a single law at international level, global law, global market, globalization, global way of lawmaking process through the general consensus and consciousness of different nations, from south to north, east to west, whatever. That concept is slowly deteriorating now. You have to revisit, relook at the local level. Of course, it also started happening at European Union and as well as USA, right? Through this debacle or debate, whatever you call it as, with respect to Brexit in the European Union, and what is now currently happening in USA with reference to encouraging the local employment, or for that matter, local innovation, and to trying to cater to the local needs, right? So which cannot be termed or which cannot be considered to be bad, but it is very much required. You have to strengthen your feet, then only you can talk about your head, your hands and all. So that feet is your local need, right? So we cannot argue, cannot complain or contemplate anything negatively when societies or nations started to read their perceptions in the current COVID scenario, not only in the COVID scenario, but in the scenario where the GDP are going down and the market is going down and the economy is slowing down. In this context, is the need to revisit and reformulate the text and context of international law in the COVID-19 plus scenario. That is also applicable for international intellectual property law as well. because the entire gamut of international intellectual property law, which is again coming from the above, when it gets implemented at local level, and the local markets or local societies or local nations may not be having the proceeds seriously felt for themselves. If I go with India, in the Indian IPR offices, it could be your patent office, it could be your copyright office, or for that matter, trademark office. It is less than 20% of the IPRs which are actually granted to the local or Indian entities or Indian people. The rest of the 80% patents, copyrights, or trademarks, the general IPRs, are actually going to non-Indian entities or non-Indian personalities. So it is happening in most of the developing nations or in most of the South, the so-called South, where their legal frameworks with respect to intellectual property at a domestic, national, or local level is actually immensely contributing to encourage innovation and creativity for the entities or people coming from outside the border, coming from outside the local frontiers. But it may not be true in the cases of, say, European Union, USA, or Canada, which are most civilized nations or developed nations. There it may be reverse. 80% of the innovation and creativity, including innovation and creativity in the context of COVID vaccine finding, and in that 80% may be going to the Canadian or European or US entities or individuals, companies, or universities for that matter. So scenario is completely reversed there. So this is also a focal point in the context of COVID-19 scenario. When you talk or when you argue or observe or formulate your own suggestions with respect to implementing, executing intellectual property laws at local level, when you demand the local nations to respect the patent granted to the so-called contextual COVID vaccine by the Canadian Patent Office or European Patent Office, or for that matter, American Patent Office. You cannot, if you expect the same reciprocal arrangement, reciprocal contribution by India, or for that matter, the South Asian nations, by respecting the so-called patent granted in these developed nations, or if you expect the India or such other South Asian nations to go for exclusive marketing rights or to arrive at certain reciprocal arrangements in lieu of patents or whatsoever, there may be some problems in the domestic levels, especially in India, because there is the provision under the Indian IPR law, especially Indian patent law, where it has got every power to patent or taking back the patent in case of public emergency or public exigency. So now COVID-19 is a public emergency, it's a public exigency. So in this scenario, you cannot demand India or any developing nations for that, or even any nation for that matter, follow mutandis and mutandis as it is the international mandate. So implementation of international law, the current COVID scenario, is not literally possible at a domestic level. As it is not possible, because every domestic nation will try to use the exception or exception, right, in the fullest possible way. Like people used TRIPS agreement, Article 27 subclass B, in the context of right to health. Same Article 27 subclass 3 in the context of public health, right, which was debated during the Doha round of international lawmaking. Right to health versus intellectual property debates which took place during Doha round of negotiations, right? So similar kind of situation is prevailing now. So you cannot expect the nations to follow the mandate obligations which have been formulated at international level. It is not just confined to general international law, but as well in the context of international intellectual property law, where in the case of public emergency or exigency, instead of granting patent or copyright or any such other intellectual property protection to the university, the laboratory, or the individual or entity who is producing the vaccine, government may acquire it on its own, or government may obtain patent on that particular innovation for itself. So in the current scenario, it is not possible to demand the stricter, fullest implementation of international intellectual property law. So the future of international intellectual property law in the context of COVID scenario needs to be revisited, because that public exigency, public emergency, or the pandemic situation, whatever it is prevailing currently, you will have to give weight to that, because people will have to survive first. Then they can talk about innovation and creativity. Then they can talk about the growth of economy and GDP, right? across the globe. Now, nations stopped talking about GDP, economy, industry, and all during the COVID pandemic. Nations are actually, international society is actually talking about surviving, right? Now, in the COVID scenario, it is the survival instinct, right? The so-called very famous scientist John Darwin, right, talks about that the basic biology theory, survival of the fittest. So, in the current COVID scenario, the survival of that nation, the survival of that international treaty or that international law, which is fit in the current scenario. I'm not saying, I'm not talking about the fittest economy, strongest economy, fittest or most viable law. The law which is viable to be implemented in the current scenario. The law which finds its suitability scenario, depending upon or that nations or that particular society's prevailing situation wherever they are actually living in. For example, African societies or the South Asian societies, which are poor or which are not having affordability to purchase this vaccine, right? So in such situation, what will happen? The governments in these African nations or Asian nations, or for that matter, the nations which are having poor societies, they would not like to grant patent. They would not like to implement the international patent law or international IPR law, for that matter, at reciprocal level. So you cannot contemplate execution of international mandate with respect to COVID-19 related vaccines. The entire, whatever research is happening or whoever is involved in that work, that would go to entire international society. The law that is prevalent now may not be clearly used or clearly implemented in this scenario, because people may go about using some amount of discretion, or they may go read up and read down by using that public exigency or public emergency or epidemic scenario in the current context. So whatever may be the law that you're talking about contemplating, whatever may be the way that by which you have formulated the law, it may be by way of treaty, by way of private international law, or by way of general international law through your civil society's contribution, civilized nations' contribution. Not only in the context of intellectual property law, but in general context also, the COVID scenario has thrown open a particular challenge, a serious challenge to the implementation of international law. Generally, people say, scholars say that international law is a toothless tiger. It has got no tooth. It cannot bite. There cannot be any sanctions imposed for the violations of international law. But we have seen how societies, how certain nations have imposed sanctions on other nations by approaching international legal mechanism. For example, in 1999, when nations like USA and European Union, when complied before WTO against India, that India, having ratified WTO TRIPS agreement, is not implementing the international intellectual property law. So on that compliant, when WTO dispute mechanism was giving a judgment, right, during that time, India happened to amend all its intellectual property law related agreements. So that dispute happened to throw open an opportunity for universalization or globalization of international intellectual property law in that scenario. So every challenge throws open an opportunity. Similarly, now this COVID-19 is also throwing open a challenge wherein we have to think in terms of localization of international law, not globalization of international law. Global level philosophy, global level theory, global level mandate, all these things may not fit into the current scenario. You have to think in terms of what your local needs are, what is suitable for your local purpose, how exactly your local purpose can have international visibility, how this local mandate can be felt across internationally, not for international implementation, but for international acceptance. Right? When you accept India's policy, it doesn't mean that you are following the policy in Canada, but you are just respecting it. When Canadian policy has been received by India, right, or acknowledged by India, it doesn't mean that India is following Canadian policy. It respects, it acknowledges. That means Canada having its own local scenario. So that scenario we need to know, we need to acknowledge and respect. So we cannot demand for the implementation of the international mandate in the current scenario with respect to any domestic nation or any national jurisdiction. That is including implementation of international intellectual property law as well. Though these international dispute settlement mechanism or international lockouts, whatever we call it as, International Court of Justice, European Court of Justice, WTO dispute settlement mechanism, or WIPO related dispute settlement mechanism, have spoken about a number of policies or doctrines with respect to implementation of international law. And those policies, doctrines, and implementation mechanisms may not go that relevant in the current scenario because it's an emergency, it's an exigency. And there is a huge amount of public demand for making certain vaccines, drugs, medicine, pharma to be available, to be accessible, to be affordable at local level. And every international player, every international association, every international agency and international lawmaking institute should think in terms of local needs, local aspirations, local perceptions, and localization of international law, including that of international intellectual property law, in the background of COVID-19, which has thrown open this particular challenge to the frontiers of international law, especially globalization of the international lawmaking process and as well implementation of international law at a domestic level. There is a serious challenge, and we have to convert the same into an opportunity by reformulating, restructuring international law to suit the local global needs. I hope I tried my level best to speak the topic of international intellectual property law in the current context of COVID-19 in the given 40-45 minutes time frame by the Canadian Institute for International Expertise. I thank President Abbas Poorhashemi for giving this wonderful opportunity to express my thoughts on international intellectual property law and its future, especially with respect to its implementation and localization of the gamut of international intellectual property law in the context of COVID-19 scenario. I thank you, one and all. Thank you.
Yeah, thank you very much, Professor Sreenivasulu. That was an interesting topic. And thank you, Dr. Poorhashemi. I don't know if we have a chance to answer the questions, but maybe we'd better just leave this to another time so that we can, but you can send the questions. We'll try to process them, and hopefully in the next
we can take one or two questions if we have time.
Sure.
One or two questions.
Yes, I think we have a couple of minutes.
Yeah, one or two.
Sure. No problem.
Just comment maybe.
Yes, dear participants.
Can I say something?
Yes, go ahead, please.
I don't have the... Do you have a...
Yeah, who has a question? Is it Christina? All right, let's see if we can unmute her. Yes, Christina, go ahead.
Yes, okay. Hello to everyone, and I just want to thank you to Dr. Poorhashemi for the invitation and the great presentation. Both presentations were great. And I have a comment more than a question, because I think too that after this pandemic will be different international law and everything. And I think that China violated human rights and international law, and they didn't give access to investigation to China. And I look around and I saw that I bought the masks in pharmacy in Croatia, and they're from China, and all equipment, and our government bought a lot of equipment of protection of COVID from China. They already had it, and they have only 804,000 infected people for whole China and whole period, and that they have a lot of inhabitants. And rest of the world, for example, US 6 million of infected, India 3.5, and Brazil 2. So I think that they definitely put that virus to the world. So it is inspection, in fact, investigation, international is needed, but they refuse that. So that is my comment, and I think that the international community have to do something regarding that, as a lawsuit maybe, and as Dr. Poorhashemi said. So he had a great presentation, and I just want to say that I agree with all. So
Yeah, I can
it
respond
was
on
just a
that.
comment. Yes, it was just a comment.
Yeah, I can respond on that to the from the perspective of international intellectual property law.
Yes.
That
Okay.
now there is a news that China has already developed vaccine on the COVID. So that vaccine in the current public exigency situation of COVID, they should not confine it to the four walls of China, right? They should the information regarding that vaccine or research should be shared with the international society, right? At least now they should avail this opportunity of undoing the damage that has taken place to the entire world because of this corona. So China should share that vaccine, the research proceeds with the international society, and then they should not try to get intellectual property rights at any level. So international intellectual property law segment should not allow China to obtain private monopoly rights, and should demand China to share that vaccine research proceeds to international society.
Yes, okay, thank you. But I want to say that they are working a lot and other people are blocked because we have one very big project in Croatia, one bridge, and the Chinese are making that, they are working, and when they
Okay.
product all this equipment, and we bought equipment for protection of COVID from China, everything is from China. So they are working and the rest of the world is locked. So that is something is wrong with all. That's my opinion, personal opinion and view. And
but
okay, thank
regarding
you.
other security,
Thank you so much. Thank you so much, Professor.
Kumar Aditya.
Yes.
Okay.
Thank you so much. If you think that we can wrap up this webinar, that would be great. I know there's still room to talk about different things, and especially when it comes to China and the virus and the source and the vaccine. The fact is that we can talk hours and hours and hours, and sometimes you don't know if you can come to any conclusions, because someone says the source is this, and then someone else says denies that one. They say vaccine is already out, but we don't see anything. Some countries say that we have produced a vaccine, but we haven't seen practically the good result of that one. But as you said, that pandemic has affected lots of things. It is not just the legal aspects of everything. It's the life of the people and their income, their relationships between the, I can say the parties and everything. Everything has been affected, unfortunately, but I hope we can get to the bottom of this very soon, maybe in the next 6 months or so. But thank you so much anyways. It was really great to have everyone from different parts of the world, and hope to see you again in the other webinars, and enjoy your comments and ideas and questions and everything. So thank you so much. It was a pleasure to have everyone. Wish you the best from Toronto in Canada, to all the participants from all around the world. Have a great day and night.
Thank you so much.
Bye.
Thank you, Professor.
Bye.
Thank you, Professor Krishna.
Thank you.
Thank you all.
Thank you.
See you later. Bye.
See you. Bye.
Bye-bye.
See you. Bye-bye. Bye.